Our next speaker, the first discussant, is Professor Nico SCHRIJVER. Professor Nico SCHRIJVER is a Professor Emeritus of Public International Law at Leiden University. Professor SCHRIJVER, the floor is yours.
Excellencies, colleagues and friends, what a pleasure to participate in this conference. I'm deeply grateful to the organizers for having invited me, and of course also for the excellent arrangements and the hospitality. I listened with great interest and admiration to the rich presentations of my colleagues this morning. And before raising some questions and making comments, at the outset, a few reflections on the appealing theme of the conference, then, now, and the future. As regards the then, we should not forget the context in which the Law of the Sea Convention was drafted and concluded. To a certain extent, an offspring of the movement for a new international economic order of the 1970s, to accommodate the interests and needs of the developing countries, which would be trampled underfoot in case the free market principle of first come, first served would have continued in fisheries and exploitation of minerals. UNCLOS is also a response to the serious environmental concerns as regards, among others, pollution and preservation of the environment. Concerns impressively recorded by the 1972 Stockholm Environment Conference and also addressed during the 1970s in a host of treaty-making activities, and of course, among other achievements, resulting in Part 12 of the Convention on Protection and Preservation of the Marine Environment. And my last then relates to the Cold War. During the third conference on the law of the sea, still fully in place and reigning. And as regards the now, we have on the one hand impressive progress, and on the other hand more serious problems than ever. Impressive is the number of parties to UNCLOS, nearly 170 states and of course the European Union, and the acceptance of major parts of it in customary international law. In addition, from the 1990s, several important additional sea-related multilateral and regional treaties have been concluded, and they provide bone and flesh to the rules of reference at various places in UNCLOS. Furthermore, as examined by President Haidar and other speakers, we also have 30 years later a solid body of case law, clarifying and also developing the concepts, the principles and rules of the law of the sea, for example, most recently in the landmark advisory opinion on climate change by ICLS. But the now is also characterized by alarming facts relating to the environmental degradation, including of the Earth's most vital ecological functions, such as the climate system, stable weather patterns, and characterized by depletion of natural resources and still alarming pollution. In the now, we may be at best moving somewhat in the right direction in addressing these concerns, but obviously we are moving way too slowly. And therewith we put the future, our third word, in jeopardy. It is still more destruction of the environment rather than conservation and reconstruction. This week I lectured in Bozen to an enthusiastic international law undergraduate class of more than 100 Korean students at Pyeongjang National University. And I realized that all of them were not only born after the conclusion of UNCLOS, but also well after its entry into force. And they were all millennials. And on 27th September of this year, that brings me to it, the United Nations adopted, without a vote, the Pact for the Future. And the pact also includes various interesting paragraphs on managing the seas and the ocean, preserving the marine environment and combating climate change, building on the Sustainable Development Goals, and of course, in particular, on SDGs 13 and 14. And there is to the pact also an annex with a declaration to safeguard the needs and interests of future generations. And among many other principles, there is guiding principle 5 of a clean and healthy and sustainable environment where humanity lives in harmony with nature, appealing to urgently address the causes and the adverse impacts of climate change and scaling up collective action to promote environmental protection. And here we have the compass for the future. Turning now, Judge RHEE, to the two presentations, I'm certainly happy with the establishment of an increasing number of MPAs on the one hand, and on the other with the conclusion of the BBNJ Treaty. That is not to say that I do not have concerns and some questions. The phenomenon of MPAs is somewhat new and still evolving. And my question to my colleague James Harrison is, do you see the MPAs ultimately emerging as an additional maritime zone and exclusively linked to coastal states? And if so, could this be viewed as a further element of the sea rush of coastal states, qualifying, perhaps restraining, the scope for collective action on the seas and the oceans as a common good? Or is the MPA, by definition, an area within the limits of national jurisdiction? If not, the question arises, how do the MPAs relate to deep seabed mining activities by the International Seabed Authority in the seabed area beneath that MPA, and how do they coexist? When seabed mining activities will impact the water column above the area of seabed mining activities, can, and if so, how should the two regimes complement each other for the sake of protecting the marine environment? I guess an MPA should be connotated with a ban, or at least a restriction on exploitation activities such as extensive drilling for oil and industrial fishing. Nonetheless, activities will take place, including managing environmental protection and sustainable use of resources. My question is, what is left in the MPAs of the principles of UNCLOS and the BBNJ Treaty and the CBD as regards the respective regimes for access and benefit sharing, including of science, marine technology, and capacity building? How to embed, how to integrate MPAs in wider management regimes of the seas and the oceans, including fisheries and global environmental regimes under, for example, the climate conventions and the Biodiversity Convention and UNCLOS. Turning to Professor Gemma ANDREONE, she made a very interesting plea for the intersection of protecting the marine environment and combating climate change. And she has presented in an admirable way what harm results from human activities both on land and at sea, such as overfishing, polluting maritime transport, including overflight, and mineral exploitation. She highlighted procedural obligations on her slides, but basically she took rightly also on board substantive obligations. And of course in line with the finding of the International Court of Justice in the pulp mills case that these go hand in hand, and that there is, I quote the court, a functional link in regards to prevention between the two categories of obligations, unquote. Because next to the substantive harm prevention obligations, there are the related procedural obligations. So there is a lot of attention for the problems of using the oceans as a common dumping place, a common sink rather than a common goods. However, there is relatively little attention for to what extent the seas and the oceans can be used for purposes of carbon dioxide removal, CDR. So the oceans as a carbon sink, a storage house, or through geoengineering and biotechnology as a space to seek to capture CO2, to decarbonize, to desalinate. That, of course, would be quite a paradigm shift. Human activities not harming the climate system, but rather seeking to restore it by man-made innovative techniques at sea for temporary or permanent storage, for CO2 capture, for CO2 removal. Perhaps a new opportunity for the oceans to be used as a laboratory for new concepts. Of course, a precautionary approach is warranted, just like in the field of deep seabed mining. However, I am not convinced that that should immediately result in a NIAT, in a halt, a moratorium on carbon dioxide removal through geoengineering and bioenergy, but rather call for experiments at an explorative stage now, since we are really far behind meeting the targets under the Paris Agreement. The BBNJ Treaty applies to the high seas and the area, that is the deep seabed area, beyond the outer limits of the continental shelf claimable by coastal states. I fully understand that the BBNJ Treaty limits itself to areas on Earth and does not address outer space and the celestial bodies. However, I would like to question the mere spatial approach of the new treaty. Areas beyond national jurisdiction as opposed to areas within national jurisdiction. And that does not reflect the reality of the environment as a whole for our purpose of marine biological diversity of areas beyond national jurisdiction. Biodiversity doesn't know whether it is within or beyond a national jurisdiction. A functional approach would be more logical. It is an established scientific fact that the environment is connected by air mass, by water cycles, by geological structures, by biological diversity systems, and other special ecosystems, such as the ocean circulation systems. So if anything on Earth does form and serves as res communes, to employ the term of my compatriot Hugo Grotius, these global natural systems do. It is a pity, in my view, that the BBNJ Treaty is not, or not more explicitly, applicable to global natural systems and fails to make the interaction between a spatial or zonal approach to a more holistic approach. This would have been more fitting for a treaty with such a strong ecological orientation. Furthermore, we of course employ a variety of terms and principles in international law to denote the global commons. Not only global natural resources, but also the common heritage of humankind and common concern of humankind. It is notable that the BBNJ Treaty itself makes a reference in its Article 7 on general principles to the principle of common heritage of humankind only. And that is of course the term of UNCLOS and only applicable to the international deep seabed area and its natural resources. It is interesting to compare the tenets of UNCLOS and the BBNJ Treaty on the one hand, and those of the biodiversity and climate conventions on the other. And the latter two employ the term common concern of humankind. Of course, a term which does not appear in UNCLOS, but it could have been added in its more recent implementation agreements, including the World Fisheries Agreement and the BBNJ. It is now widely acknowledged that the environmental dimension is currently an integral and inherent restrictive element of the common heritage principle, as well as that of common concern of humankind. And such environmental obligations have also been recognized to have an erga omnes character. And this means that all states owe their obligations in this field to prevent harm to the environment of areas beyond national jurisdiction towards all other states and to the international community. And this also implies that all states are entitled to invoke the responsibility of other states for the breach of their obligations in this regard. And this brings me, Judge RHEE, to my last questions to the panel. Do the presenters agree or disagree with me on the limitations of the spatial approach in the BBNJ Treaty? And do they share my regrets that the principle of common concern of humankind, as it features in the climate and the biodiversity treaties, has not been taken on board? Thank you for your kind attention.
Thank you very much, Professor SCHRIJVER, for your very insightful and also thought-provoking comments and questions. Now, the last speaker of our session this morning, no, this afternoon now, okay, is Director Vladimir Yares. Yeah. Mr. Yares is the Director of the Division for Ocean Affairs and the Law of the Sea, DOALOS, Office of Legal Affairs of the United Nations Secretariat. Director Yares, the floor is yours.
Thank you, and I hope it works. It does. Thank you, Judge RHEE. Excellencies, ladies and gentlemen, like others before me, I wish to start by expressing my deep appreciation to the Ministry of Foreign Affairs of the Republic of Korea, the Korean Society of International Law, as well as the International Tribunal for the Law of the Sea, for inviting the Division for Ocean Affairs and the Law of the Sea of the Office of Legal Affairs of the Secretariat of the United Nations that I represent to be on the panel of this excellently organized international conference on the law of the sea, which features prominent scholars, practitioners, and experts in the field. And I know that we all enjoy very much the presentation. And this morning we have heard another two very much thought-provoking presentations, as also it's testimony by the questions just asked by my predecessor, Professor SCHRIJVER. The first presentation by Professor James Harrison on the past, present, and the future of marine protected areas in international law and policy, and the second one by Professor Dr. Gemma ANDREONE on marine environmental climate change, addressing, among other, climate change and the law of the sea in the context of intersection between climate change and the marine environment are very useful and very informative. Both panelists made a very thorough and largely convincing analysis of issues that are related to marine protected areas and to the environment, marine environment, and the climate change. I'm not going to comment on details of these presentations. Let me use this time, because a lot of references have been made to the environment, to the agreement under the United Nations Convention on the Law of the Sea on conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. I have only 13 minutes to go, so I'm going to use the acronym now, from now on, BBNJ agreement, which deals with NPA beyond national jurisdiction, but which also has an ambition of addressing the triple planetary crisis of climate change, pollution, and loss of biodiversity. So we need to a little bit always to go back and to refresh our collective memory about the genesis of the BBNJ agreement and perhaps of its immediate future. So let me start by highlighting how we get to the agreement, what is actually in the agreement itself, because it's not the agreement only about environment, marine protected areas or area-based management tools, and what are the immediate next steps. As it has been already highlighted, this is the third agreement adopted by the international body under the United Nations auspices in relation to the implementation of the United Nations Convention on the Law of the Sea. We have to remember there have been many words said about the convention being a living instrument, but also about how this convention perhaps may need to be modified or to meet current challenges. We have to remember that the first agreement, implementing agreement relating to the implementation of Part 11, has already changed the legal effects of Part 11 of the convention. So there is always room for further development, progressive development of the law of the sea. The convention was, as we have also heard, complemented by another important agreement dealing with sustainable fisheries, most specifically with straggling fish stocks and highly migratory fish stocks. And finally, most recently, last year on 19th June, the agreement under the United Nations Convention, the BBNJ agreement, was adopted. And as it has been rightly pointing out, we should not call this agreement the High Seas Treaty. This is something invented by the civil society in order to promote a better understanding, perhaps a better acceptance, I would rather say, of this instrument. No, this instrument covers the high seas and also the international seabed area. That means all areas beyond national jurisdiction. And that means this is partially answering also the question that has been just posed in order to seeking the relationship between the potential use of area-based management tools, including marine protected areas in the zones beyond national jurisdiction. So this is just a reminder of the spatial application of that BBNJ agreement. And we know that the BBNJ agreement is about conservation, but also sustainable use of marine biological diversity. But in fact, it has been to a large extent motivated by the need to address many threats and pressures that have cumulative impact on the marine biological diversity. And in the words of science, we know that these main threats are climate change, pollution of the marine environment, including and mostly perhaps from the land-based sources, and overfishing. But we also know that the international governance is to a certain extent fragmented, that several organizations have competence in these fields. There was no overall cross-sectoral mechanism to address cumulative impacts in areas beyond national jurisdiction. And also we know that there have been legal regimes, different legal regimes that apply to that area. Well, for those who would think that it's easy to progress fast with the in the context of progressive development of the law of the sea. Let me just remind the audience here about the BBNJ timeline. From the very start until the day today, it took 20 years to arrive at the moment when we are eagerly awaiting the entry into force of this agreement. I'm not going to go into details, but only the Intergovernmental Conference took close to 4 years to finalize the negotiation of this agreement, which is not as complex as the Convention. The Convention has 320 articles and 9 annexes. This agreement is relatively more modest, but it's quite significant in its complexity and its impact that we do not yet fully understand, because many of these impacts will be also contingent and dependent on the decision of the conference of the parties. So what is in the agreement? As I've said, this is not only about area-based management tools, including marine protected areas. This is one of the streams, one of the part, and one of the mandated focuses of this agreement. But the first chapter, actually the first part of the agreement, deals with marine genetic resources, including the fair and equitable sharing of benefits from these resources. And this is about use of the genetic information in the light of the most recent scientific discoveries, potential for producing medications, etc., and generating considerable benefits, both monetary but also non-monetary, in terms of scientific information. Another important part and elements is an element of this treaty is the environmental impact assessment part. Now, we are talking about the Constitution for the Oceans, how important framework it is for regulating activities over the past 30 years after its entry into force. But we know also that there was a lack of sufficient implementation of Part 12 of this United Nations Convention on the Law of the Sea on protection and preservation of the marine environment. So this Part 12 is actually being operationalized right now by this agreement. And finally, the most pertinent at this moment element of this treaty is capacity building and transfer of marine technology. But of course, there are a lot of cross-cutting issues, including the settlement of disputes procedures. So the agreement does matter. It's creating a path towards a greater level playing field. It's a vital step for preserving of the marine environment, which is crucial for the future of our planet. It's a significant development for ocean affairs and the law of the sea. And it's perhaps a crucial contributor to global targets. It has been open for signature on 20th September, and it will remain so until 20th September 2025. It will enter into force after 6 years instrument of ratifications, and the first conference of the party has to be convened within 1 year from the entry into force. The current status of the agreement is we have 105 states which have signed the agreement, and 14 ratifications, and this is a kind of illustration of where we stand in terms of regions as well. And finally, let me move to the next step. Our division is performing the secretariat functions until the secretariat to be established under the agreement commences its function. Currently, we'll be supporting the process of the preparatory commission, which will meet in April and August of the next year, which is a very complex, because there are a lot of complicated issues before the first conference. And there is also substantial activities on our part to promote a better understanding of this agreement and for the preparation in the force. Now, let me continue by noting that we live in a very complex and challenging geopolitical environment, with the key pillars of post-war international law, including the Charter of the United Nations, are being ignored or outright desecrated. In this environment, as far as the oceans are concerned, we still enjoy a state of relative stability, thanks to a large extent to the United Nations Convention on the Sea, which is an instrument, as it already has been stated, of enduring relevance. 30 years after its entry into force, it continues to be a source of stability and legal certainty. At this time, we have, as I've said, entered a new era of implementation and progressive development, especially through the BBNJ agreement. And this is a good example of the continuous efforts of member states of the United Nations and other stakeholders to address current ocean-related challenges in the context of this Convention of UNCLOS that is called the Constitution for the Oceans, not because of the nature of its language, but because of its important legally binding framework that it provides for all activities that are to be conducted in the oceans and the seas. We are still trying to understand how international law, and in particular law of the sea, given the importance of the oceans in climate regulation, could be of use in the context of adaptation and mitigations of the impacts of anthropogenic activities, especially the climate change. And given not so stellar record as it concerns the implementation of Part 12, there are plenty of questions to be asked, which we probably won't have time for. But the issue is that whether the establishment of marine protected area is something that could assist us in mitigating these impacts. Because as we know, the biggest threat to the marine environment, especially to marine biological diversity, comes from the climate change, overfishing, and land-based pollution. The issues arises how international law, in particular the Convention and its implementation agreements, including the BBNG agreement, can be of help of addressing urgently and effectively the triple planetary crisis that means climate change, pollution, loss of biodiversity, and we also take note of the ICLS advisory opinion. And what will be the next steps to make this advisory opinion the most effective and impactful? For instance, one of the questions that comes to my mind, since the marine environment is affected by climate change caused by anthropogenic pollution, mostly from the land-based activities producing greenhouse gases emissions, should there be environmental impact assessments required for those under Section 4 of Part 12 of the Convention? The question has been already also asked by Professor Harrison, to which extent the BBNG agreement can be efficient in assisting and aiding the coming Montreal Global Biodiversity Framework with the foreseeable future within the time period 2030, given the relatively long path towards a possible future decision of the BBNG agreement Conference of the Parties on the establishment of marine protected areas. Well, finally, question for scholars, does the BBNG agreement modify the legal effects of the Convention as far as the NPAs are concerned, or is it just a treaty which is existing in that respect alongside with UNCLOS? Well, I'll stop right here, thanking everyone. My time is, I think, running out. But all these issues are very relevant issues. All these questions that we have been asked are very pertinent. And we all wish that this conference, as many other endeavors that we are undertaking, contribute not only to the better understanding of the Convention, the BBNG agreement, and the current challenges, but also to their effective solutions. And with that, I would like to thank you, Mr.
Thank you, Director Yares, for your very kind introduction to the BBNJ agreement and also in very valuable comments. So, given the constraint of time, I'd like to give Professor Harrison and Professor ANDREONE some minutes to respond to the comments and questions.
There's a range of rich and varied comments. I will select 4 or 5 points, I think, to make in response. And I will start with erga omnes and common concern of humankind, because it's obviously something that is prevalent in the Convention on Biological Diversity. Biodiversity has been recognized as a common concern of humankind. And I think it's relevant to what I was saying because of the nature of the obligation means states can hold each other to account. The ICLS advisory opinion was very good. If there was one thing I would have liked to have seen in it, it would have been an explicit recognition of the erga omnes character of the marine environmental obligations. But I think I take the view that they are, and that states can therefore hold each other to account even if their own particular interests have not been affected by a breach. Whether that is done through litigation or probably more likely through the sorts of institutional arrangements I was talking about. And leading on to another question that I think Professor SCHRIJVER had is, how do you coordinate what different coastal states are doing? I think something I skipped over in my presentation because I was talking far too slowly was the role of regional seas bodies in coordinating coastal state action. And that is happening around the world. Most regions, whether or not they have a treaty-based regional seas body, or the North Pacific Ocean is a very good example where there is no treaty in place, there is an action plan. But states are still collaborating, exchanging information, and in a sense, formulating a common agenda on the priority habitats that should be protected, and then going back and following up on that. And I think those softer accountability mechanisms, which are quite common in the international environmental law field, can be very useful for overseeing these due diligence obligations and ensuring that those conversations carry on an ongoing basis, and states gently pushing each other progressively to do better. A related issue is the constraints, I guess, that the convention may place, and it's again something I had on my slides but skipped over. It was talked about yesterday: due regard, good faith, and obviously the Chagos MPA arbitration is an excellent example of those obligations being applied to the establishment of MPAs. So states cannot act completely unilaterally, and they need to consider and take into account the interests of other states, and that may be neighboring states, it may be activities beyond national jurisdiction. And I think coordinating the regimes within and beyond is a really important element. I don't think the BBNJ agreement necessarily hinders that. I think there are several reflections in the BBNJ agreement for the need to take into account what coastal states are doing. That can be done through the consultation process on proposals for MPAs. But equally, coastal states need to take into account what is happening in areas beyond national jurisdiction, because Professor SCHRIJVER is perfectly right to say that ecosystems don't respect these man-made boundaries, and we do need an ecosystems approach. So it is cooperation between these different actors and different regimes that becomes critical in that respect. I'll say something on carbon sequestration, because both of the commentators raised the climate change issues. And I think MPAs have two potential roles here. I think it's recognized that MPAs can be a useful tool for protecting what are called blue carbon ecosystems, seagrass, kelp beds, mangroves, a range of different marine ecosystems which can effectively sequester carbon dioxide and keep it out of the atmosphere for very, very long periods. And I think identifying areas where these blue carbon habitats exist and protecting them through marine protected areas can be a really useful way of linking up the MPA agenda with the climate change agenda. Also identifying areas where we can restore these habitats, where they may have once been but are degraded, but actually taking active steps to restore them and then protecting them. And there's a link there between biodiversity targets on MPAs and restoration, both of which feature in the Global Biodiversity Framework. I think MPAs more generally play a useful role in addressing climate change impacts on the ocean, because they can be used just to reduce the other specific threats that are facing and give marine environments just a little bit less pressure. Climate change we can't stop overnight, but there are other stresses that we can reduce and give the space and increase the resilience of marine ecosystems from these longer term slow impact events, as the climate change regime would frame them as. And let me finally say something about deep seabed mining, because it was specifically mentioned in the relationship between MPAs and deep seabed mining. And I guess I'll maybe take it as a question of the relationship between BBNJ and Part 11, perhaps. I mean, one of my observations in my presentation was that the COP cannot force other existing bodies to act on its agenda. It has a much more facilitative role of encouraging, recommending, and it's clear that the BBNJ agreement has to be read not only in a way that respects competences of other existing bodies, but for the International Seabed Authority, even more significantly, the agreement has to be read in a manner that's consistent with UNCLOS. Because the Seabed Authority is created by UNCLOS, I think that gives it almost a unique position And so what we need is a good working relationship between the International Seabed Authority and the COP to ensure that those two bodies are working harmoniously as partners, equal partners, in an exercise to protect the oceans. And of course, the ISA has its own existing tools, which are, if they're not marine protected areas, they're area-based management tools, and it's another acronym, folks. I think we need a glossary somewhere. APIs, areas of particular environmental interest, is a concept developed by the International Seabed Authority, essentially a sectoral area-based management tool. And those particular tools can be used in coordination with measures taken by the COP to achieve this overall protection. But it is a matter of cooperation at the end of the day. And I think we need the states. And let's face it, at the end of the day, it's often the same states, just in different organizations. And we as an international community need to get together and ensure that these organizations are working harmoniously on our behalf.
Thank you for all your questions. Many of your considerations, I share the considerations of both discussants, and I just want to say that I was there during the negotiations as member of the Italian delegation, the negotiations of the BBNJ agreement. I always speak in my personal capacity anyway, and concerning the carbon dioxide removal and your specific question on this, I think that the main problem we have nowadays is the lack of knowledge of the ocean, and the even very low investment in terms of funding for ocean knowledge, for discovering how it working oceans. So maybe this should be one of the main point to take into account, in sense to understand if some activities could be and how it could be done. But anyway, using the sea as a mean also for restoring, it's something very, very useful. I mean, and always considering the application of a precaution, the principle of precaution, that is a solid basis for every activity. Concerning spatial scope of BBNJ, even though James already said this, I also confirm that this is a critical point for the protection of the marine ecosystem as a whole, and actually both the fish stock agreement and the BBNJ agreement do not regulate the environmental protection and resource conservation of the maritime zone within national jurisdiction, and this is one of the most problematic issue that depends on the will of negotiators of the states that generally presume that the protection, the environmental protection and of the national maritime zones is higher. There is a general presumption in this sense, but this is also why I think that it can be a cooperation and that could be improved by the COP, a cooperation between coastal state and the COP and all the bodies of the BBNJ. But it is important to recall that also the purpose of the consultation when establishing an area-based management tool is actually to notify to the coastal state in order the coastal state has the possibility responsibility to check that everything is in conformity and complying with its interests and rights. So also concerning the idea of the common concern. We have discussed a lot on the necessity and on the delegations were debated for years for the application of the common heritage of mankind to marine genetic resources as well, but finally it was not accepted, so except for the introduction of this principle of the common heritage of mankind as set out in the UNCLOS. So the reference is to the area. So the principle should apply just for its application to the area. Actually delegations did not deal with another concept that could be the common concern. Because the other concept that was in the discussion was benefit sharing. What this show us that the BBNJ was not only an environmental treaty, not only dealing with environmental issues, but also with management of IC's maritime spaces. So how to manage them, not necessarily to protect.
I originally intended to open the floor to the audience, but unfortunately, it does not seem to be the case. We are already 20 minutes past the allotted time. I sincerely apologize for that. If you have any burning questions, maybe you can approach our panelists after the session is over. Thank you very much.
Thank you very much, Judge Lee, for your work, and appreciation also goes to our speakers. Once again, let's give a big round of applause for our moderator and our speakers up on the stage.